Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through the California Invasion of Privacy Act and the way it relates to technologies used by businesses and websites. This law, often referred to as CIPA, is a California law that regulates the interception and recording of communications. It has increasingly been interpreted in the context of digital technologies used by businesses, including tools that capture or monitor communications on websites and online platforms. The law was enacted in 1967 in the state of California, and during the 1970s through the 1990s, additional provisions were introduced to address emerging communication technologies. Starting the year 2000, courts began applying the law to digital communications, and between 2022 and the present day, lawsuits have targeted session replay tools, chat monitoring software, and similar website technologies. Many of these claims rely on Penal Code sections 631 and 632, which address wiretapping and recording confidential communications. The CIPA can apply to businesses that interact with California residents, which includes companies operating websites and mobile applications. It can also apply to online customer support platforms, and call recording systems may fall within scope as well. Last but not least, analytics and behavioral tracking tools can also capture communications that may trigger the law. The law includes several exemptions, such as law enforcement activities conducted with authorization, certain service provider operational monitoring, and authorized investigations. Businesses should review their responsibilities under the law. They should minimize the amount of personally identifiable information and should not intercept communications without the consent of all parties. In addition, confidential communications should not be recorded without consent. Organizations should review technologies that capture communications. They should also inform users when monitoring or recording may occur. Website owners should review the tools installed on their websites that may capture user communications. Session replay tools, for example, may record user interactions on the website. Chat support systems may also record conversations between users and the business. Call recording widgets can capture voice communications. When these tools capture communications, website operators should obtain user consent before the recording or monitoring begins. Organizations should also implement additional transparency measures, such as providing disclosures within their privacy policies, which can explain when communications may be recorded. They should identify third-party technologies used to capture communications and should maintain records of user consent. Under the law, individuals have the right to pursue legal remedies. People may file lawsuits when communications are intercepted or recorded without consent. Many claims involve website monitoring tools such as session replay or chat systems. Individuals bringing claims may request statutory damages or other remedies available under the law. The law is primarily enforced through civil litigation. Individuals may bring private legal actions when communications are intercepted without consent. The California Attorney General may pursue criminal violations of the statute. Local district attorneys may also enforce the law. Civil claims may include damages of $5,000 per violation or 3 times actual damages. Thank you for joining us. At Clym, we're here to help you navigate compliance with ease. Visit us at clym.io to learn more about our all-in-one digital compliance solution.